Okay, good afternoon, everybody. My name's Hani Malla. I'm a judge of the Appellate Division. I also wear another hat in that I am privileged to be the chair of the Supreme Court Committee on Diversity, Inclusion, and Community Engagement. Our panel, which involves supporting juror impartiality, is staffed by two very esteemed panelists that I'd like to take a moment to introduce. Farthest away from me is Judge Ed McBride, who was appointed to the bench in 2010. He is the presiding criminal part judge for Camden Vicinage. He's also the chair of the Conference of Criminal Presiding Judges. He is the former chair of the Supreme Court Committee on Family Practice and co-chair of the working group on juror impartiality, whose work we're going to be discussing today. Next to him and to my immediate right is Passaic County prosecutor Camelia Valdez. She was appointed in 2009, and she has a notable list of firsts that I'd like to discuss. She is the first Latina prosecutor in New Jersey, the first woman prosecutor in Passaic County, the first lead prosecutor of Dominican ancestry in the United States. She manages what is arguably the largest law firm in Passaic County, 185 employees, and she is a career prosecutor, having done so for the city of Newark, served as a deputy attorney general and also as an assistant U.S. attorney. To the extent that I can provide a roadmap for today's discussion, it is to talk about the work that has gone into the initiatives that the court is proposing to deal with the issue of implicit bias, to discuss those three initiatives in particular, and then to move to hopefully a question and answer session, and perhaps maybe even a question and answer session as spicy as the last one that we had. So let's dive right in. If I could, we can go to the next slide. So as I indicated, the presentation today is going to deal with really three prongs. That is a juror video that has been created by the court. The second being proposed new voir dire questions that tackle the issue of implicit bias. And finally, a model jury charge. You can go to the next slide, please. As I think it's important to point this out. The court's initiative, or the court's dealing with this issue, is something that precedes Andujar. For those of you who are nerds of the case law like I am, you know that Andujar came out, was argued in, I believe, March of 2021, and came out in July of 2021. The court's notice to the bar on this issue precedes all of that, and that is precisely because this is an issue that the court has been dealing with for quite some time, and its genesis really precedes Andujar. Andujar obviously brought it to a head. However, the court, with the assistance of its committee on jury selection, with the assistance of its committee on the model jury charges, and with the assistance of my committee, the Diversity, Inclusion, and Community Engagement Committee, has been working on this matter for quite some time. Next slide. Again, the work began with the establishment of the working group in 2019, and that working group produced several items that we're going to be talking about in just a few minutes. So again, I did want to emphasize that because this is a long-standing initiative that has been undertaken by the court and led by Judge Grant and the chief. So what I'd like to do is show this video. This is the first of the three initiatives that I discussed at the outset. Let's go ahead and play the video, please.
responsibility of all jurors is to reach a fair verdict based on the law as the judge explains it and on the evidence in the case. The court's goal in every jury trial is to seek jurors who will decide the case before them without prejudice or bias, because under our Constitution, everyone deserves a fair trial. As jurors, we fulfill this responsibility by remaining impartial or neutral until the jury reaches a verdict. Remaining impartial throughout the trial means ensuring that we are not guided or influenced by our biases or any preconceived ideas about the case. What are biases, and why should we all keep improper biases out of the courtroom? Biases are prejudices in favor of or against a thing, person, or group. All of us, judges, lawyers, and jurors, have biases. Biases can be favorable or unfavorable, explicit or implicit. Basically, bias is prejudging, whether in a positive way or a negative way. Explicit biases are the biases that we are aware of and which consciously affect our ability to be neutral about some things. Implicit biases are the biases that operate unconsciously. It's been proven that most biases happen at an unconscious level. Researchers have found that unconscious bias is a part of how we all think and process information. It's important as jurors to be aware that unconscious bias exists. Once we understand what it is, we can address the effects of unconscious bias while serving on a jury, so we can be sure we are making objective decisions and treating everyone fairly. To better understand both conscious and unconscious bias, let's consider a few examples. We might have a deep-seated belief that basketball is a better sport than football. We might prefer strawberry to raspberry jam. These are conscious biases that are not inherently negative. However, our conscious biases can lead to intentional and harmful discrimination. Unconscious bias is different, and it's something we all have simply because we're human. It's the set of automatic preferences deep in our brains that instantaneously influence our decisions and how we perceive people and situations without our conscious awareness. Without giving it any conscious thought, we might be more likely to friend someone who plays soccer rather than someone who bowls. We might have an unfounded idea about the personality of people who drive red sports cars, or we might have a feeling about a person's background because of the individual's race, ethnicity, or national origin. Unconscious biases help us make quick, efficient judgments and decisions with minimal mental effort. Honest, intelligent, good people are affected by unconscious bias every day. Because these unconscious biases are automatic, we use them to make judgments and decisions without realizing that is what we're doing. But if and when we just stop to consciously think about it, we might decide our initial hasty judgments don't actually fit with the information we are being presented with, and with what we really know to be fair. Considering all the information, instead of making a decision based on the information that comes to mind most quickly, can help us to avoid relying only on our preconceptions. The shortcuts on which our minds rely can be helpful in our daily lives because they help us to make good and efficient decisions based on our past experiences. But some of the shortcuts we use, the ones driven by unconscious bias, can have negative consequences, causing us to unknowingly make unfair distinctions among individuals when everyone should be judged fairly. When we are aware that all of us have unconscious biases, stereotypes, and attitudes, we can look for these biases and have a better chance of preventing unconscious bias from affecting our decisions and judgments as a juror. In fact, jurors have reported that once they were made aware of unconscious bias, they were able to check in with themselves during the trial and evaluate their decision-making. This kind of conscious evaluation of our decision-making can help us to avoid mistakes based on unconscious bias. We can help prevent unconscious bias from guiding our judgments by taking time to examine what's influencing our decisions. So, don't hesitate to ask yourself about unconscious bias. And at the end of the trial, during your deliberations, if you think unconscious bias has shaped your evaluation, think about the evidence again with this video in mind. The fairness of a jury's verdict depends on the impartiality of the jurors who serve. As you continue your jury service, consider whether your biases relate in any way to the case in which you are asked to serve. Think about whether you will be able to keep your biases from interfering with your promise to remain impartial throughout the case. During the jury selection process, you can ask to speak with the judge about any of your biases, explicit or implicit, that you feel may get in the way of you making a fair decision. There is no judgment and no penalty for informing the judge of your biases. In fact, doing so shows that you understand the importance of juror impartiality. It is the commitment of each juror to remain impartial throughout the trial that ensures the fairness of the jury system. You are about to become the most important part of the most important tradition in our justice system, the right to a trial by jury. Thank you for your effort to ensure that everyone receives a fair trial.
Okay, next slide, please. So this video, which was produced on behalf of the court, obviously draws on excerpts from provided to us by the clerk of the United States District Court of the Western District of Washington. However, what I would like to point out is what's highlighted in the second bullet point, which is the care that was taken in assuring that the video was as inclusive as possible in terms of the populations that we reach and in terms of the folks that we draw on to be in our to serve as jurors. I would also like to highlight some other subtleties, and that being the length and the format. Any of you who are on social media, for say Instagram or Facebook, and you see an ad, that is the format in which people's attention is grabbed these days. It's done in short video clips, and it's also done by way of imagery more than text. I think the video strikes the right balance in terms of trying to grab jurors' attention and also get or drive a very important point across. So I'm going to turn things over to Judge McBride, who will talk to us about the second initiative of the three that we're going to be addressing today.
We can go to the next slide, please. The sequence of events for the prospective jurors is that they would see, in addition to the standard current juror orientation video that gives the jurors an orientation about a trial, they would then see this video or whatever is ultimately approved by the court. And part of this whole process of unveiling it, it's a world premiere today for the video, is to elicit comments from people about, from conference participants and those who are watching, and any other members of the bar and members of the public, about that manner of presenting to prospective jurors the subject of implicit bias or unconscious bias. The next step in the process for the jury selection process is when the pool of jurors is, in the olden days, assembled en masse in a big jury assembly room and then sent up into a particular courtroom as potential jurors, or in our modern hybrid jury selection mode, people are all gathered together in a Zoom room and are given preliminary instructions that cover a host of things, most of them an introduction to those prospective jurors about what's going to come next, which is covering the questions and all of that part of the process. The proposal to address and enhance juror impartiality is to inform jurors about this subject, then incorporate it in as part of this preliminary instruction to the jury. And so this is the proposed language that was put out for public comment. This is not a world premiere. This has been out for public comment back in February, I believe. A number of comments were submitted from organized bar, from individual members of the bar, from at least one member of the public as well. Many of those commenters noted that, gee, we wish we could see what the video was in order for us to assess how effectively we think this language is when it is read to the jurors by the judge. The jurors don't get copies of this. Generally, some judges may give jurors copies of the preliminary instructions. I think most don't. But that's this context. So it's the video, then this language, which appears at the appropriate segment of the preliminary instructions to the jury. The public comment document that's out there was able to be longer. I think the document that is part of the materials for this conference don't replicate the entire 9 or 10 page preliminary instructions to the jury, but it fits into right after a current discussion that has for many, many years has said to the jury, the first step in a jury trial is the selection of the jury. This process is important because both the state and the defendant are entitled to jurors who are impartial and agree to keep their minds open until a verdict is reached. Jurors must be as free as humanly possible from bias, prejudice, or sympathy, and must not be influenced by preconceived ideas. This would then come next, the language that is highlighted and underlined here. The comments already received back in the springtime, and I expect that we will receive more. Are helpful, will be helpful. There are a lot of different views, a lot of well-informed views about how to talk about this subject. And there's some, I suppose, view of should we talk about it at all? That maybe we'll get a question about that later. But in terms of how to talk about it, this is the proposal that was put out. And again, this language was crafted initially by the working group that Judge Ironson, who was a panel moderator earlier, and I were the co-chair of the working group internal within the judiciary. And then the proposal was reviewed by other standing committees, put out by the court for public comment, and now it's put out as part of the proposal overall of this conference. So then in the sequencing of events, then the jurors are informed about this information as part of the overall preliminary instructions to the jury. That process, that segment of the process is immediately followed by the questioning of the jurors, and on our current system, using the written questionnaire and going over each of those questions. And then the proposal is for part 3 of the 4-part approach here, movie, preliminary instructions, or 3 parts, I suppose, juror voir dire. We will now move to that because that's chronologically the next step in the process is preliminary instructions to the jury, then written questions. Our current system requires the use of at least 3 open-ended questions for jurors. Practices vary. Lots of judges allow a lot more. Some judges don't. The proposal is to include 2 open-ended voir dire questions. And so if we can have that next slide, please. And Prosecutor Valdez will talk about these next 2 items.
Thank you, Judge. As part of the work that we're doing, the 2 proposed questions are behind me. And so this would be part of the questioning of the jurors. And as you can see, the first question is, in the juror orientation video and my introductory remarks, the concept of implicit bias was defined and discussed. Do you think you will be able to decide the case fairly and impartially and to be mindful of the potential effects of any biases you may have, explicit or implicit? Please explain. So that will give the potential juror an opportunity to explain what their understanding is. And I should have said that in this 3-pronged process of the video and then the questioning, there are many, many resources for all of you to consider as to what would make a more complete explanation to jurors. That first question is there to assist in vetting out who should sit and who should not sit. Because at the end of the day, this is what we're talking about today. Who sits in the jury and who does not, and why? And then once we have that group of people selected, what instructions are they given about how to discharge their duties? Next slide, please. The second voir dire question has to deal with witnesses. Some of the witnesses, parties, lawyers, jurors, or other people involved with this case may have personal characteristics such as their race, ethnicity, or religion, or backgrounds different from yours, or they may be similar to yours. Would those differences or similarities make it difficult for you to decide this case impartially based solely on the evidence and the law? Please explain. Judge McBride?
Yep. Again, the proposal is that these two open-ended questions would not replace the current requirement that there be three open-ended questions used. When the court adopted and implemented the report and recommendations of Judge Lisa's committee, it set forth a set of sample 10 or 11 or 12 open-ended questions. They are very commonly used in a lot of cases. These would not be a substitute for that three. So in other words, effectively, there'd be five open-ended questions, these being a required two of them, or some ultimate variation. But that's the recommendation that's out there right now. Then after the selection process is completed, there's another set of instructions that are provided to the jurors, the instructions after jury is sworn. So you then have a group of 14, 15, whatever, in a criminal case, whatever it is. These instructions, by the way, are taken from the proposed criminal instructions. So these would be after the jury is sworn. And again, they are in a context where the jurors are told that following summations, they'll receive final instructions on the law from me, the judge, and you'll then retire to consider your verdict. You are not to form or express an opinion on this case, but are to keep an open mind until you have heard all the testimony, have heard summations, have had the benefit of my instructions as to the applicable law, and have been instructed to begin your deliberations. Then this language would be inserted as part of the instructions to the jury after they had been sworn, but before they hear any opening arguments or any evidence in the case. And this reads, as you read it, the responsibility is all jurors is to reach a fair verdict based on the law as the judge explains it and on the evidence in the case. Court's goal in every jury trial is to seat jurors who will decide the case before them without prejudice or bias, because under our Constitution, everyone deserves a fair trial. That may sound familiar. That's a sentence from the video. That's like on purpose to reiterate the same points. Jurors fulfill this responsibility by remaining impartial or neutral until the jury reaches a verdict. Remaining impartial throughout the trial means ensuring that jurors are not affected or influenced by biases or any preconceived ideas about the case. And then there's some slight amendments proposed thereafter. Trial goes on. There are the final instructions to the jury at the end. And so this proposal then also includes, and if we can go to the next slide, a proposed new provision in those final instructions to the jury. And this also, in a broader context, it's in the part of the instructions that just before this say, as jurors, it's your duty to weigh the evidence calmly and without passion, prejudice, or sympathy. Any influence caused by these emotions has the potential to deprive both the state and the defendant of what you promised them, a fair and impartial trial by fair and impartial jurors. Also, speculation, conjecture, and other forms of guessing play no role in the performance of your duty. And then this new language would be read to the jury as jurors. Your oath requires that you not be affected or influenced by any personal likes or dislikes, opinions, prejudices, sympathy, or biases, including implicit or unconscious bias. During your deliberations, if you think unconscious bias is affecting your evaluation, think about the evidence again with the video and this instruction in mind. All right, we can go to the next slide, please.
Did you want to do this one? Okay. Okay. So interlocking support. So what are we trying to accomplish? We talked about the video. We talked about the new questions for your consideration. And we talked about the enhancements to the jury charges. And one of the things that we are striving to do with this work is to make sure that when jurors come to the courthouse, they understand what the expectation is of them. And so with the video, the concepts of primacy and recency, what do they hear first? What do they hear last? And what do they hear in between is important in order for them to be able to properly discharge their functions. So you see at the slide behind me is that we want to make sure that we are educating jurors about implicit bias. And I'm sure during the Q&A part of our presentation, there'll be questions about whether we should be even talking about this. And I think most of us agree that we should, but how we go about that conversation is really up to us. The efforts to educate jurors about implicit bias and to support them and in many ways empower them to discharge their duties so that they understand what it is that they are, the expectation for them. Those efforts will be ongoing. The court is welcoming any feedback from all of the stakeholders. And I think it is important to address the fact that all of us as partners in this system have to first examine our own biases, examine our own preferences as judges, as prosecutors, as defense attorneys, so that we can better recognize when we see it happening in the courtroom. So all of the things that we're talking about, and hope that in this initial and important first step provides the space to discuss it. So I am very excited to be part of the process of reform. Reform is never easy. We've saw that with the sea changes when we implemented bail reform in the state and all of the different things that we have done over time. So it's important for us to continue to talk. I am biased because I am from Passaic County and I see that Judge Capicella is here. We have an extraordinary collaborative relationship. And so anytime that we're implementing something new, there's a lot of discussion that happens between the judiciary and the prosecutors and the defense bar. And that's, I think, what has led to our success. So that is what we have for your consideration. I want to, as you are thinking about these things, just very quickly point out a few things that you may want to consider in terms of the resources that are out there and what led us here. And one of the cases before Andujar that I will draw your attention to is the case of Pena Rodriguez versus Colorado, Supreme Court case that talked about this issue of implicit bias. And in fact, in that case, that final verdict was impeached because of anti-Mexican comments that were made, that jurors reported. The ABA toolkit has, the American Bar Association has put out a number of things that will also be helpful to the consideration of what we're doing and help us compare what we're doing. I'm proud that we are joining the ranks of Washington, California, Arkansas, and Illinois, which have already started this effort. So there are models for us to consider. And achieving an impartial jury is the ultimate goal. I think we can all agree that that is the goal. How we do it really will depend on us. So thank you, Judge.
All right, next slide. We will end where we started the day, and that is if you accept what Professor Glaude said as true, and I certainly do, that the issue of racism and bias is something that we have not tackled the way we should, then I believe you would accept the next premise, which is that this is not the end of the court's initiatives to tackle the issue of implicit bias, but simply the beginning. And this is something that's ongoing. And as part of the interlocking supports that Prosecutor Valdez spoke about, it is not just the court releasing initiatives, but also the court hearing from court users, from attorneys, from the public defender, and from jurors about what can be done better to reach folks in our system. So I'm going to kick things off with a question from the audience, and it is as follows. Is there any risk that raising the issue of implicit bias might make some jurors less comfortable sharing their views during voir dire? And I don't single anyone out.
I suppose there is a risk. It was interesting, though, looking at the video that Mr. Kokoris showed earlier and the comment being made about the kind of information that was elicited from that one particular juror about their views about race, perhaps would never have come up, that no one would have known. So, I mean, I think and I'm not equating, that exact question was different than this question, but the idea of exploring something that is an undeniable phenomenon in human decision-making, and and the struggle, I think, is to try to do it in a way that does not convey judgment, that does not convey disapproval or anything like that. I often stress in jury selection the segment that's now in our existing instructions. There are no right or wrong answers, and honesty is what we need. And so I think, yes, is there a risk that this will make some people uncomfortable? Many people, perhaps. I don't know. Introspection is sometimes uncomfortable, but I think it's essential that we raise the subject that this affects human decision making, and it can have negative effects that we're not aware of, that we can help check ourselves so that we are committing ourselves as a juror to trying to decide the case based just on the evidence and not based on the initial automatic reaction that we don't control when we hear or see certain things and how we react to them that's kind of embedded in us. So yes, there is a risk that it might make some jurors less comfortable. I'm not sure about sharing their views, because I think this questioning would be, I would certainly recommend, my practice has always been when I do open-ended questions is to do it at sidebar, or now in Zoom world, do it in a breakout room, or have all the jurors in a breakout room and bring them, just with the lawyers and the defendant and the judge, so that people do feel comfortable talking about something, as we do with a whole host of other potential subjects, victimization and other things like that. So I think there are ways, both in the manner in which the judge addresses the juror and in the setting in which that interaction with the juror takes place, that I think would greatly reduce any discomfort. But I think we'd be kidding ourselves if we thought that it's not going to be there. I think it will be.
Okay. I'm not sure if you wanted to chime in.
I was just going to comment that I agree with Judge McBride, but I think as stakeholders in this process, we should be creating spaces like this conference where we normalize having difficult conversations. And so when we're talking about someone's freedom or money damages, when we're talking about civil cases, difficult conversations, especially when you're trying to change something for the first time, really instruct our work. So if we avoid it because people are uncomfortable, then we're missing out on opportunity to really effectuate important reform.
So I have other questions, but does anybody in the room have any questions to follow up? Yes. I could introduce you, but I'm going to let you introduce yourself. So, yeah.
Like Judge McBride, think about Mr. Kokora's presentation in the context of this, and it seems like the questions that are being proposed have been very carefully vetted and are very thoughtful, and I'm grateful to everyone's work on that. But I also wonder about who's asking them and the impact that has. And so like Prosecutor Valdez just said, I don't think we need to be afraid of making people feel uncomfortable. That's the point, right? These are good questions because they make people uncomfortable, not despite that. But what we want to avoid is kind of saying, I'm the judge. I'm hinting strongly what the right answer here is. And so I want to make sure that those questions are sufficiently open-ended. And the first one that Prosecutor Valdez read, which I don't have at the ready in my head here, but it seemed like it was kind of a closed-ended question followed by a please discuss. And I guess my concern, and I don't know, but my concern is that people will feel like there's the right answer to give. And that feels counterproductive to the broader conversation starting that we should be doing.
I wonder if there's, I mean, again, I thought that video of the jury selection in Kentucky was very interesting, but I wonder, is there any concern with the discussion they're having about, especially the individual who said he was prejudiced? Is there a concern with polluting the rest of the panel?
And so, I mean, Joe can talk more about this, but we were talking during the break. I don't know that the lawyers in the Kentucky presentation were as skillful as others might have been, but I think, look, that guy wasn't going to serve on the jury, right? The answer he gave was vile. But a skilled attorney doing attorney-conducted voir dire could probably parlay that answer into getting the other, whatever it was, 31 jurors to talk about that, right? So, Mr. Johnson, you heard Mr. Jones's statement that Black people are inherently more violent. What do you think about that? And so, Mr. Johnson, I think the first person's gone, but maybe you get a good answer from Mr. Jones about how he feels about it. That really starts a conversation.
We're fortunate in that we have skilled attorneys doing a lot of the litigating, but I wonder, does this create a whole new crop of PCRs where the defendant says on appeal, my attorney was a numbskull and asked all the wrong questions, and is that a concern in moving from judge directed voir dire to attorney directed?
I don't know.
For another day.
But right now, I mean, just to be fair, right now the issues on appeal are the judge messed it up. So it's not it's a different legal theory, but it's not creating a new cause of action, just a slightly different.
Touche.
It's interesting. Many of the sample open-ended questions that have been used for years and years and years start as kind of a yes or no question. And and I've become increasingly sensitive to that kind of dynamic and have kind of modified them in some instances. And I can see your point that, could a point be made that maybe we elicit, that the sort of don't even have a question mark at the end of it, kind of have it as a declaration and then saying, what do you think? Kind of an approach, but because that is something that we want to avoid, because we do want to avoid people thinking that there is a right answer to the question, subtly or overtly, I think, in order to give the court and the attorneys the opportunity to assess whether this person would be able to discharge their obligation to keep an open mind until the end of the case and decide the case only on the evidence and the instructions from the court.
I'm not sure, Jessica, do we have more time left in this panel or? Okay, all right, well, no better time to end. Thank you very much, everybody.